company law. My name is Tracy Bird and I run SCVO's Trustee Network, which is sponsored by CCLA, who are the UK's largest charity fund manager. So thank you all for coming along today. We've got quite a lot of people attending, which is great. So while everyone is joining, do take the time to introduce yourselves in the chat and maybe tell us a little bit about your thoughts about the upcoming changes and how they might affect your charity. And if you've got any particular questions that you might have, do put them in the chat and we look at these at the end. And this is also going to help us test that everything's working as it should be. And if you're not already on mute, if you could put yourselves on mute. Just to note, we've got closed captions enabled today, but you can turn them off at the bottom of the screen. And as you've heard, we're recording the webinar. But if you do have any kind of confidential issues you'd like to discuss and would rather not do that in this session, you can get in touch with us afterwards. We will send out all the slides to you afterwards in a follow-up email, plus the recording. But as I say, do put any questions you've got or comments, and we will have time to look at these at the end. So I'm delighted today to be joined by Laura Kirkman from Gillespie McAndrew. They're one of our partner firms who provide advice for SCVO members as part of our free legal advice service. Now that's open to any SCVO member organisation with an income of less than £500,000, and it gives you access to legal advice on all manner of issues from governance and charity law to property, employment, that kind of thing. Enough from me, I think. I'm going to hand over to Laura now, who will share her screen and go through her slides. And over to you, Laura.
Thanks very much, Tracy. If you just bear with me 2 seconds, I'll get my screen, my slides up.
That's great, Laura. We can see that.
Is that working for everyone? Super. Yeah. Thanks very much. Yes, so as Tracy mentioned, just a quick introduction. I'm a senior solicitor here at Gillespie McAndrew, working in the charities team. Over the course of the next hour or so, I hope to give you an update on some of the recent changes and developments in the law which trustees or people working with charities should be aware of. And we'll look to focus on the more sort of practical implications for trustees and charity staff rather than some of the technical legal detail. But I also quickly just want to run through some of the key aspects of charity law which haven't changed, just as a brief refresher, and then there should be plenty of time for a question and answer session at the end. So there are a number of areas of law that will affect charities over the course of their lifetime, in addition to charity law, such as company law, employment law, health and safety regulations, data protection, just to name a few. But today's focus is going to be very much on charity law. So as I say, we'll just run through a quick refresher of the key aspects of the Charities and Trustee Investment Scotland Act 2005, which will hopefully be familiar to some of you on the call. And then we'll look at the changes that are being brought in by the Charities Regulation and Administration Scotland Act 2023. And then finally, I just want to consider how the Economic Crime and Corporate Transparency Act 2023 will affect charities. And that will be particularly relevant for charities which are incorporated as companies. So just turning first to the 2005 Act, this Act did a number of things which are still very much in force and very relevant for charities today. First and foremost, it established OSCR, which continues to act both as a registrar and as a regulator. As a registrar, it continues to maintain the Scottish Charity Register, which tends to hover around 25,000 charities or so. And then as a regulator, OSCR is interested in what you're doing, how you're doing it, what you aren't doing, but you should be doing. It's there to protect the brand, if you like, against reputational harm, which can affect individual charities, but also the sector as a whole. It helps to maintain and build public confidence, and many of the reforms brought in by the 2023 Act do seek to build on that public confidence in the sector by looking to increase transparency. The 2005 Act created the modern day charity test, which remains largely unchanged by the recent reforms, subject to one new addition. Just going through the test quickly, sort of as a summary, charities must have exclusively charitable purposes. There are 15 recognised purposes in the Act, and this has not changed by any of the recent reforms. But it's not a closed list, so you can get creative and try and persuade OSCR if you want to. You must continue to always get OSCR's consent before making any change to your charitable purposes, no matter how small the change is. You must continue to provide public benefit through the activities that you run and the services that you offer. And you can't be imposing any unduly restrictive conditions on access to your services. Now, the new part of the charity test that was introduced by the Charities Regulation and Administration Scotland Act 2023 is that you must be able to demonstrate your organisation has a connection to Scotland. This condition is intended to dissuade applicants from further afield who don't have charity status in any other jurisdiction and who are essentially looking for some form of legitimacy by being able to say that they are a charity registered in Scotland and then quote a charity number. Previously, OSCR did not have any discretion to refuse an application if the applicant met the charity test. So if they could show that they advanced one of the charitable purposes and that they provided public benefit. This led to a number of charities, quite a small number, but still there, who are registered in Scotland, but who are carrying out activities elsewhere. And OSCR has really little to no oversight of their activities and also little to no jurisdiction to take any action if things start to go wrong. The new provision essentially gives OSCR an out to reject an application in those circumstances. For any existing charities who are already registered with OSCR, it is possible that OSCR could withdraw charitable status, but only where this forms part of an inquiry process. No charity should ever receive notice of a withdrawal of status as a bolt from the blue. It's not what the legislation intends, and it's not how I would expect OSCR to act. In our experience, they have always sought to engage with charities and trustees and solve problems in a collaborative manner. The general duties of trustees haven't changed, and these continue to be found in section 66 of the 2005 Act. So if you're not familiar with this section, or perhaps you've got some new trustees on the board, it's always good to just bring their attention to it and refresh your mind. So just as a quick summary, trustees must always act in the best interests of the charity. You must always act within the charitable purposes and powers. So please know your constitution, read this regularly and have it accessible to all trustees. Act with care and diligence with everything that you do. And you must continue to recognise and manage conflicts of interest. Turning now to some of the updates. In 2019, there was a consultation on Scottish charity law. This was conducted by the Scottish Government, but it had been requested by Oscar. It had been nearly 20 years since the 2005 Act, and Oscar essentially had a wish list of shortcomings in that legislation that they wanted addressed. And the end result was this Charities Regulation and Administration Scotland Act 2023. This act has come into phases over the last year or so and continues to do so. There has been mixed reaction to the 2023 Act. It's generally felt it addresses some of the shortcomings, but not all. So I just want to run through some of the key provisions in a little bit of detail, and I'll go through them in sort of the order that they've come into force. So last year, Oscar gained the power to appoint interim trustees. Oscar could previously appoint interim trustees, but only if that was requested by a charity. And so this new power means they can now do so of their own accord. How effective this power is going to be is still really to be tested, but it's aimed at charities, helping charities in situations where they don't have enough trustees to make decisions. You can't form a quorum during meetings, or where you've fallen below a minimum number of trustees required by your charity's constitution. It could be a lifeline for charities struggling with some governance gaps, but it does remain to be seen how Oscar will source suitable trustees. From which pool of people will they ask to be a trustee? Sometimes the number of trustees in a charity will fall below a minimum number due to perhaps death of a trustee or incapacity. And in those situations, you might find people are willing to step in. But other times, it will be due to poor governance and lack of planning. And in those cases, I imagine people will be more unwilling to act. Oscar's powers have been further extended, particularly in relation to positive directions and the ability to investigate former charities and former trustees. Historically, Oscar's powers were somewhat limited. They could issue restrictions, so they could tell a charity what not to do, but they could not compel a charity to take positive action. So that's now changed. Since last year, Oscar has gained the ability to issue positive directions. So they can now require a charity to do something specific. So it could be to update your governance documents, to improve your financial controls, or to take steps to address any safeguarding concerns. This gives Oscar a more proactive role, helping charities to resolve issues and improve their governance, rather than simply reacting to a problem after it has occurred. In the same spirit of strengthening oversight, Oscar now has the power to investigate former charities and former trustees. Previously, once a charity was removed or had been removed from the register, or a trustee had stepped down, Oscar's jurisdiction effectively ended. And it created a bit of a gap, particularly in cases where concerns only came to light after the charity had wound up or a trustee had moved on. Now, Oscar has the power to look back and ask questions where there is public interest to do so. So this might include investigating misconduct that occurred before a charity was dissolved, or reviewing the actions of trustees who may have contributed to serious governance failures. Again, this change helps to build public confidence in the sector, and it sends a clear message that accountability doesn't end when a charity closes its doors or when a trustee resigns. Taken all together, these powers do give Oscar a more flexible and responsive toolkit. But again, it's not about Oscar being heavy-handed. They're just wanting to ensure that charities are well run, trustees are supported, and that the public can trust the charity sector. This year, in June, we saw the introduction of the Register of Mergers. As of yesterday, when I last checked, there were no entries on this new register, so it's still to be tried and tested. But we do know that the register will not be retrospective. So it will only look at mergers which have happened on or after the 30th of June 2025. The register looks to mirror the system already in place and maintained by the Charity Commission in England and Wales, and that has been in place for some time. And really, one of the key motivations behind the Register of Mergers is to protect charitable legacies. So essentially gifts that are left to charities in someone's will. These gifts can sometimes fail if the named charity has merged and wound up, and the executors are unable to identify the successor organisation. This new register is intended to act as a public record, helping executors, solicitors, and others trace the destination of merged charities. By providing clarity on which charity has taken over the activities and the assets of another, the register should help to ensure that legacies reach their intended charitable purpose, even after structural changes. Then on the 31st of August this year, the criterion which automatically leads to the disqualification of trustees was updated. Senior management are now caught by the disqualification criteria. So this extends to any person undertaking work of a senior nature, whether or not that is reflected in their job title. And it also includes volunteers who undertake a senior management function. The range of criteria leading to automatic disqualification has been extended. So it now includes convictions for money laundering, terrorism, and bribery. And some of you might be aware of this already, but just recently, since June this year, charities have been able to submit detailed trustee information to Oscar. So names, addresses, dates of birth, and contact details. And this information is submitted through the Oscar Online service. And these details are currently being held securely by Oscar and being used to contact trustees as and when needed. But the real shift is going to come next year. We don't have a date yet, other than just early 2026, when we know that Oscar will begin publishing the first and last names of trustees on a charity's registration page on its website. This is going to apply to all charities and to all trustees, unless there is a legitimate safety concern that justifies withholding the information. It is quite surprising that Oscar weren't doing this already. We have sort of lost count of the number of times that we've been asked where we can find the names of trustees on Oscar's website. And up until now, or up until early next year, the answer has always been that you can't find this information publicly. Oscar never published it, and in a lot of cases, Oscar don't or didn't have up-to-date information of who the trustees of a charity were. But this change is going to bring Oscar much closer to the transparency standards of Companies House, where the names of directors are routinely published and updated. previously, there was no legal duty for Oscar to publish names, and trustees were required to tell Oscar who the trustees were in their annual return, but often that information was up to a year out of date, sometimes even longer if your accounts were late. So it's going to sort of really help to increase the transparency and make it easier for the public, for funders, and for regulators to know who is actually responsible for running a charity. Also, from early 2026, we will see Oscar publish unredacted annual returns and accounts. So the actual accounting and reporting requirements that you might all be used to, those requirements haven't changed themselves, but the accounts and annual returns will soon be published without the removal of any personal information. And again, this is aimed at increasing transparency. So in order to prepare for these upcoming changes, I would think of this time as a sort of governance health check. What do you want the public to see? So do an audit of who your trustees are and who your members are if you don't have this information to hand. Ensure that your accounts are presented in a way which are happy to be published. Identify anyone, hopefully it's no one, who might be caught by the new trustee disqualification criteria. And please watch out for updates from Oscar. They are updating their website and putting out little news bulletins quite regularly. So I would encourage you to just keep an eye on that. And I just want to now turn to the Economic Crime and Corporate Transparency Act of 2023. It's a piece of legislation that's not strictly charity law, but it is going to be highly relevant for many charities and those charities who are incorporated as companies. It is one of the most significant reforms to company law in probably over a century. And it is part of a broader effort to tackle economic crime, improve corporate transparency, and just generally strengthen the integrity of Companies House. It gives, much like the 2023 Act gave Oscar new powers, this Act gives Companies House new powers and introduces new responsibilities for company directors, and that will catch people who are also charity trustees. So just to be clear, this legislation applies to charitable companies. So if your charity is also registered with Companies House, it does not apply to schemes, to charitable trusts, or to unincorporated associations. It is a very long piece of legislation, and again, it is being rolled out in phases. But two key milestones have already passed that I just want to draw your attention to. And you might already be aware, but since March of last year, all companies will have had to register an email address with Companies House. That is not being published, and it can be updated by yourselves at any time, but it just allows Companies House to more efficiently contact directors if needed. And since April of this year, Companies House opened a voluntary ID verification service for directors. And this is in preparation for the next major change, which is coming very soon, just in a couple of months. From the 18th of November this year, ID verification will become mandatory for all directors. And this date essentially marks the start of a transition year, during which all directors must verify their identity in order to continue submitting filings. So this is going to include trustees of charitable companies whose names are already listed as directors on Companies House. You may have received communications from Companies House about this already. I know they are sending out emails and notifications. But essentially, if you haven't verified your ID, you soon won't be able to submit key filings, such as your confirmation statement. So it is important to act sooner rather than later, and please don't ignore their communications. The process to verify your ID is relatively straightforward. They are encouraging you to use the Companies House service, which is available via the gov.uk One login. And you'll need a phone or a computer, something with internet access, and also a camera. And then a form of ID. And I believe they ask for a passport or a driving license. Once you've verified your ID, you'll receive a personal code and a verification statement, which you will need to include with your filings. And if you are a trustee of multiple charitable companies, you will need to go through this process separately for each one. So if you've done it once for one appointment, unfortunately, it's not going to cover all your appointments. I believe as well, if you don't have access to the appropriate technology or you don't have the ID documents that they are looking for, there is an option to verify your ID in person. I think that's at the post office or some banks and building societies. The Act also requires people with significant control, or PSCs, to verify their identity too. This is probably not going to be as relevant for most charities, but it is worth checking your company's register just to confirm whether any PSCs have been recorded, because they will need to go through this process as well. It is a practical change, but it's also quite symbolic, reflecting a growing emphasis on transparency and accountability. And we can see that both in the corporate world and in the charity sector too. So just to sort of take a few minutes to reflect on that information and what it means for yourselves as trustees, charity staff, perhaps advisors. We've looked at the sort of foundations of charity law in Scotland and the enduring relevance of the 2005 Act. And we've looked at how the Charities Regulation and Administration Scotland Act of 2023 has brought in a range of reforms which are aimed at improving transparency, strengthening governance, and building public confidence in the sector. Some of the changes are already in force, like Oscar's new power to appoint interim trustees and issue positive directions. And others are just round the corner, such as the publication of trustee names and charity accounts. I mentioned there has been a mixed reaction to the 2023 Act. It does introduce a number of these practical and targeted reforms, but despite these improvements, there are still several gaps, and some people feel that the Act missed opportunities to address some broader structural issues in the sector. For example, the 2023 Act does not really mention at all unincorporated charities or the conversion to a SKIO process. So many unincorporated charities face challenges around liability and legal personality. The Act hasn't done anything to simplify or support the process of converting to a SKIO, which could really have had quite a meaningful impact on governance and risk management for a large number of organisations. The Scottish Government has acknowledged these limitations and has committed to a wider review of charity law in the future. So this suggests that the 2023 Act isn't the end, but is just sort of the start of the process. And just as a quick refresher of the sort of practical steps that we are recommending charities take at this time. So please do review your governance documents if you haven't done so for a while. So that would be your constitution, if you're a SKIO, or your articles of association for companies, your rules if you're an unincorporated association, and just make sure that they are reflecting the current law and best practice in the sector. Please do an audit and know who your trustees are and know who your members are. Keep accurate records and make sure that OSCR has up-to-date information. If you're not a company and you haven't been used to telling Companies House changes of directors and charity trustees, this is something that you're going to have to get used to when telling OSCR of this information. And do just sort of prepare for the extended transparency. Think about how your accounts will appear when they're published without any redacted information, and think about how the trustee details and names will appear. Are you happy with what the public are going to see? Are all your trustees aware that their names will soon be published? Does anyone have any concerns or questions about this? Just check for any disqualification risks and make sure that nobody in a senior role is caught by the new criteria. And again, please do engage with OSCR's guidance and also with SCVO's guidance, because they do keep their website up to date as well. So I would just say thank you very much for joining today. I'm more than happy to take any questions if people have them. And also my details are just on this slide at the moment. So please do feel free to get in touch if you would like to discuss anything afterwards.
Thanks, Laura. That was great.